So my attorney just uploaded and shared a document with me called a de novo. What is that?
The request for a de novo hearing is not something that we see very often in family law, but they definitely do happen, and they are nothing to be concerned about. So more often than not, when we have preliminary hearings in family court, those hearings happen in front of an associate judge in Tarrant County. Other counties don't have associate judges, so the procedures are a little bit different. Let's assume that we're in Tarrant County for now. So if you have a temporary orders hearing or any sort of interlocutory hearing, so any hearing that's not a final hearing, you will receive a decision from the judge. So whether it's an associate judge's report, it's a rendition from the bench, it's a decision that you receive a few days after your hearing, that decision is going to have many components to it. If a party disagrees with any portion of the judge's ruling or with the entire ruling, they are entitled to, within 3 days of receiving that ruling, to request essentially a brand new hearing in front of, rather than the associate judge, the district judge of the court in which that associate judge sits.
Interesting. So let's say we're the ones that filed the de novo hearing. When does that need to be set?
Technically, under the code, the de novo hearing needs to be set within 30 days of filing of the de novo request. Judges have discretion to set a de novo hearing after that 30 days if the court or the parties have difficulty scheduling within the 30-day time period. But typically, the hearing needs to be set within 30 days.
Interesting. So when the hearing is reset with the district judge, do all of the same exhibits need to be shown, or can we add more exhibits?
You can add more exhibits. So really what's being heard are the same issues, but you can certainly bring more information with you to the de novo hearing if perhaps you feel as though the associate judge didn't get all of the relevant information at the first hearing. But the important thing to remember is no issue can be heard at the de novo hearing that was not heard at the initial hearing. The issues or the hearing is going to be limited to what the specific ruling was that you received from the associate judge.
That makes sense. What if opposing counsel files the de novo hearing? Are we allowed to object to their de novo?
Unfortunately, there is no real way to object to a de novo hearing. They are entitled to this hearing. They are entitled to have another judge hear essentially the same evidence and essentially the same hearing. So we can't really object, but what we can do is appear, and assuming that the de novo was filed by opposing counsel, it essentially means your side got what they wanted. So congratulations. So the hope is that you appear at the de novo hearing, you present the same evidence, the same arguments, and the district judge feels the same way that the associate judge felt.
So we just finished the de novo hearing, and the district judge ruled very similarly to the associate judge. What's the impact of that?
Basically, what the district judge says goes at that point. So if the district judge reads the associate judge's ruling, hears all of the evidence for him or herself, and essentially makes the same ruling, that's an affirmation of that lower judge's ruling. So you exist per the terms of that original order as you have been, and there's really nothing that anybody can do about it. On the other hand, if the judge makes a different ruling, the same principle applies generally. However, in limited situations where perhaps evidence was misrepresented, or there was a material omission or misrepresentation of fact, or there's some sort of factual scenario where perhaps the judge received inaccurate information, then you can file what's called a motion to reconsider. Those hearings are also going to be pretty limited to the single issue that you are asking the judge to rehear. So for example, I had a hearing once where we had a de novo hearing in front of a district judge, and the district judge, based on evidence that was presented, reduced an amount of spousal support that the opposing party was ordered to pay to my client. The district judge, in doing so, had relied on a very specific dollar figure that had been presented by opposing counsel that, upon further investigation after the hearing, was an inaccurate representation of, at that point, what the party's estimated tax bill was. And so we filed a motion to reconsider to have the judge reconsider the amount of spousal support ordered based on the fact that the opposing party had inaccurately conveyed to the judge how much money the parties owed on their annual tax bill. Does that make sense?
That does make sense. That was a great overview of what a de novo hearing is. If you have any further questions about what a de novo is, feel free to reach out to us or your attorney.